Thank you very much, everyone, for joining. My name is Nigel and I'm the host today of today's Privacy Post. I'm very, very pleased that you're able to join us and that we have three marvellous speakers today. We have Paul, we have Laura, and we have Gary. And without me wishing to steal their thunder, I'll ask them to introduce themselves in turn. Laura, Paul, then Gary, and just who you are. And invite you to give a little resume about yourself. If everyone who is not speaking can go on mute, we've done this for 18, 19 months, haven't we? So, but we all still forget. Laura.
So I'm Laura. I'm a privacy and legal consultant for Kuchibu, which is a consultancy firm in Eindhoven, the Netherlands, specializing in privacy, information security, and cybersecurity.
Cool, thank you, Laura. Paul.
My name is Paul Byrne. I own a company in Jersey, Channel Islands, called Propel Forward. We're a consultancy to help small to medium-sized businesses with data protection compliance, the operational side of compliance, so that's policies and registers. We also offer data protection managers or officers positions and EU representative services, as well as training.
There's training as well, yeah. And Gary.
Good morning, everyone. My name is Gary O'Reilly. I'm a solicitor, 20 years qualified. I'm also an outsourced DPO, EU representative, UK representative, and I act as external counsel for a number of companies. To steal a term, a bit of a one-stop shop for compliance and data protection matters. Like Nigel as well, though, I'm also a recent mature graduate, having undertaken an MBA, and so that has given me a good insight into business foundation to help me with grow my company SME Comply and to put me on a good footing going forward.
Thank you, team. That's very helpful for those people who Gary was alluding to. I was very, very fortunate. I secured my Masters of Law degree in Information Rights Law and Practice on Friday at 57 without a first degree. I'd have to say I don't know how I achieved that, but we've achieved it. So thank you for those kind words, Gary. Okay, so the topics we're going to discuss today are the European Data Protection Board have issued the new Standard Contractual Clauses, and what does that mean for EU countries? We're also going to touch on UK ADASI arrangement. We're also going to talk about the Dutch regulator and finding a company for not having EU representatives, and find out what the requirements are for EU representatives, but also UK representatives under the UK GDPR. And we're also going to touch on e-privacy and cookies. They're back in the news again, and to try and look at what's new here. So I'm going to hand over to Laura, and what happens in these in Privacy Pulse is that we get questions sent in to us, and we've got a range of questions to focus the discussion. And I'm going to hand over to Laura straight away, really, because Laura, what's the story around Standard Contractual Clauses? How did it arrive, and how do we have to use them, and what are they?
All right. So the Standard Contractual Clauses, just to come back, Nigel, aren't issued by the European Data Protection Board, but by the European Commission. So they have recently updated them, and after public consultation, decided on a final version, which was released on June 4th. They're an update of existing clauses, but they have had quite the makeover. They will repeal the existing ones on 27th of September of this year, but you can still use the old ones and keep them until December 2022. So that gives organizations some time to implement the new versions. In the new versions, they've actually updated the module. So it's now a modular approach where you've got a set of clauses that are meant for controller to controller transfers, controller to processor, but also processor to processor and processor to controller. You pick which one is applicable, and depending on your situation, some of the clauses apply and others don't. So there are some clauses that apply in all situations, and some clauses that only occur when you are, for example, a processor transferring to a controller.
And then, Laura, clearly we have a range of people on the call today. When would you expect to use them? For example, if you're transferring information from the Netherlands to Germany, there's no requirement for standard contractual clauses. What sort of countries would be in scope for putting into place new standard contractual clauses?
So the standard contractual clauses are a transfer mechanism that can be used for transfers going outside of the Union or the EEA. They aren't necessary if a country like the United Kingdom has an adequacy decision. Okay. And they aren't necessary, which is also a new update that they added in the recitals, if GDPR is already applicable fully to the importer of the data. That would mean that standard contractual clauses could be used for transfers to countries, for example, in South America or Africa. But what has happened recently due to the ruling in Schrems 2, which repealed Privacy Shield, is that the Advocate General of the court actually advised that just signing standard contractual clauses doesn't actually guarantee an adequate level of protection, and that organizations have to make sure that when they're signing these clauses, that they are taking supplemental measures. So the European Data Protection Board recently published their final draft of these possible advice on supplemental measures that organizations can take in order to make sure that the standard contractual clauses that they sign actually also lead to an adequate protection level. And the Advocate General stated that it's likely that in the case of the United States, these adequate measures would be necessary because using the standard contractual clauses would leave you facing the same issues as which caused Privacy Shield to be repealed in the first place.
So in essence, Laura, what the Advocate General said is that they don't want to become a paper exercise. They have to have meaning. They have to have real validity in terms of providing security for the data subjects within those standard contractual clauses. Is that a fair assessment of the reason for the ruling?
Yeah, definitely.
Cool, excellent. Okay. Gary, you've been involved for some time, and you have not only UK but experience in Ireland as well. Beyond the standard contractual clauses, let's think about EU representatives. What are and UK representatives? What are the requirements that people need to add in beyond their standard contractual clauses?
Okay, well, what Laura was referred to earlier on was essentially Article 3.2 of GDPR, which we need to look at before we can consider what the requirements of an EU representative. What Article 3.2 tells us is that if you're processing the personal data, a controller, a processor, and you're not established in the Union, for example, the UK now, where the processing relates to the sale of goods or services, or the monitoring of behaviours such as cookies, tracking, these smart devices that record health, etc., then you need to appoint an EU representative. That representative is set out, the responsibilities of that representative is set out in Article 27 of GDPR, and that states that if you can satisfy either of those two tests, that you monitor the behaviour or offer goods or services to individuals in the EU, then unless there's a very strict exemption, unless the processing is occasional, doesn't include large scale special category or criminal data, or in fact you're a local authority, then you are required to have an EU representative. So this is all to do with the sheer worldwide scope of this legislation, GDPR, and then Article 27 allows the European Union to actually enforce the GDPR on companies outside the EU. The representative will act as a conduit between the EU supervising authority and the controller or processor, and they're able to enforce proceedings, enforce the GDPR via the European rep. So that's really the reason for it and how they go about actually enforcing GDPR.
Cool. Gary, before GDPR came into force on the 25th of May 2018, a business associate of mine in Bulgaria explained it very simply as the mechanism that has existed for years. If, for example, I wanted to import goods into the European Union, you would require a representative within the European Union to assert that the good meets the standard, has the right C certificate, i.e. the certificate which says it is available for sale and meets all the health and safety. If it was a car, for example, the emission standards, it meets all the requirements of the European Union to import that car into the European Union. Is it very similar to that?
Well, I don't think it is. That's something along the lines of a medical devices EU rep, for example, whereby you take responsibility for the product when they come into the EU. The EU rep is not liable for the acts of the processor or controller. Okay, so if there's enforcement action against the controller or processor, for example, then they may be able to issue that via the EU rep, but it's not that the EU rep is not liable themselves, whereby the medical devices EU rep is potentially liable themselves.
Cool. Okay.
It's a liability issue, yeah.
Okay, a liability issue. So just to confirm then, Gary, that the EU rep is not liable for the failure in statutory compliance of controller stroke processor.
Exactly, yes.
Cool.
Yeah.
Going back to Laura, the Dutch regulator has recently fined a company for not having a UK representative. What was that all about?
Yeah, an EU rep. So the Dutch Data Protection Authority, Autoriteit Persoonsgegevens, they fined LocateYourFamily.com, which is a website that publishes the name and address data of people all over the world without those people's consent or, well, really any other legal basis. And the Dutch regulator started an investigation after receiving numerous complaints. This was actually an international investigation and a case where they collaborated with 9 other EU data protection authorities, as well as the Canadian data protection supervisor, and they ended up fining them over €500,000 for not having appointed a EU representative.
Wow, that's a big sum of money, isn't it? That's a big sum. I said to a client yesterday, if you think compliance is expensive, try non-compliance, and that's a good example of that. You know, I'm sure EU representative wouldn't have cost them that sort of money. Gary,
just come in there.
The complexities of the landscape that we currently work in, certainly in the sphere of UK stroke EU, is the UK representative. What's that all about?
Okay, well, this is a new requirement following the end of the transition period. But so basically, what has happened is some of your viewers may have heard the term retained EU law. Essentially, what that means is that it's a snapshot of EU law that was copied and pasted essentially into UK legislation on the 31st of December 2020. One of those pieces of legislation that was copied and pasted was, of course, the GDPR, which the UK has made it into their own UK GDPR. So essentially, what they have done is they've copied the whole GDPR. So if you go through the GDPR and replace EU with UK, you essentially get the UK version of the GDPR. So if you monitor the behaviour of individuals in the UK or offer goods and services to individuals in the UK, and you don't have an establishment in the UK, then you too are required to have a UK representative. So many companies now find themselves subject to a dual regime, the UK GDPR and the EU GDPR. So yeah, that's where that has come about, Nigel. But it's essentially the same.
You're still on mute, Nigel.
Yeah. You're on
Sorry.
mute, Nigel.
I'm sorry. So I've only had 18 months of practice in this, isn't I? I do apologise. Gary, is there any divergence in UK law and EU law at the current time?
There may be. You may have to. You may have to look for it, Nigel. It's quite strange in that once we have inherited quite a lot of the EU law, you have to go. You have to look at each law in question and compare, or sorry, run it by the European Withdrawal Agreement Act, and see if it meets the criteria in that, and if it doesn't, then it doesn't fall within the UK legislation. But there's no. I don't know at this stage. I haven't had any cause to look into any aspect of EU law that has been changed really since it's come into the UK. Working time regulations, etc., remain as they did.
Cool. Okay, Paul. We've got some. I see some names that I recognise from the Channel Islands on the call today. Clearly, the Channel Islands we have Jersey, the Jersey Data Protection Law. We have the Guernsey Data Protection Law. How are things there in terms of EU/UK representatives in terms of standard contractual clauses? How's it working out for our colleagues in the Channel Islands?
Well, I mean, Jersey and Guernsey were quite ahead of the curve, if I may use that phrase, during the Brexit and the transition period, because Jersey and Guernsey immediately wrote into their own data protection laws that they recognised the UK as having an adequate level of protection well before the EU decided upon it. So that the free flow of data from the Channel Islands to the UK has been totally uninterrupted by all of this. Jersey and Guernsey will recognise the new standard contractual clauses as a method of transfer, and they will recognise the new supplementary measures that Laura and Gary have mentioned. It's interesting between the draft SCCs and supplementary measures and the actual ratified ones, the softening or the approach towards the measures that you have to take in relation to publicly accessible legislation and problematic legislation. It's an easier way around it now, although very resource intensive. The representatives, exact same requirements in Jersey law. I mean, if we want to comply with UK law, we have to, if a business in Jersey doesn't have an establishment in the UK or the EU, we obviously have the same requirements. We are a third country, although with adequacy. But it's interesting, I mean, Article 4.3 of the Jersey law, I can't quite recall the article in the Guernsey law, but we have a requirement for a representative for businesses who have no establishment in Jersey. So, I mean, a lot of countries, Isle of Man, I believe, has a requirement for a representative for businesses that don't have an establishment there. So, where countries now are using GDPR as a foundation, and they're taking it as the principles and the rights and the articles that go with GDPR, they're writing in these requirements and not necessarily regulating them. There is no regulation. Luckily, Belgium started the ball rolling with a fine. I believe Gary's going to mention one for the UK. The difficulty's always been around how to regulate an EU rep and who to fine. Well, I think the precedence has been set on that one. Well, there you go. That's my take on it.
Thanks, Paul. For those people who've not been to the Channel Islands, I'd highly recommend it if you can get there this summer. I'm a great fan of the Channel Islands. I did a lot of work for the states of Jersey government, and I can highly recommend 6 months well spent in my life. Gary, what's the case Paul alludes to in his comments?
Yeah, so I just wanted to highlight the fact that there now has been 2 cases recently in respect of Article 27 reps. So the supervision authorities are onto them, and they're checking out to make sure people have them when they should have them. The second case, it's a UK case, so it's not binding on the EU. Similarly, the LocateFamily case is not binding in the UK, but no doubt that they will be used in reference when cases come before the courts. Yeah, the UK case is a case called, bear with me, it's Rondon versus LexisNexis Risk Solutions Limited. If anyone wants a copy of that case, just let Melanie know, and I shall get it to you at the end of the at the end of the conference. So that application really was a defendant, a claimant tried to have an EU rep responsible and liable for the failings of a company based in abroad, really in a third country. The case was kicked out. The judge was having none of it, Ms. Justice Rice. She found actually that the EU rep is not responsible for the acts of the controller or processor based in a third country. But what she did say, and she did actually in that judgment give a good breakdown of what the EU rep is, what it was, and how important a role it actually is. Because up until now, people thought it was just a pretty passive role, where she totally disagrees with that. And she thought that, I'll just quote it from you. She thought that the role of an EU rep formed a very important part in a regime based on a triangular relationship between the data subject, the data controller, and the supervising authority. She found that the record keeping Article 30 obligation of a data EU rep was very important. It wasn't just a back office bureaucracy. It was required because that was all the information that data subjects and supervising authorities had in respect of that particular company in the relevant supervising authority or in the UK. So she deemed it a very, very important role, and said this one that was not passive whatsoever, was a very important role, and was a role to show that companies were engaging with the GDPR, understand its scope and provision, and accept the conditions imposed on the access to the data. She said, quite to conclude, actually, she said something that was really, really good. It signals, in other words, a recognition of the bargain involved, the burden to be shouldered for the benefits to be gained. So
that's really good. So was that the Court of First Instance, High Court?
High Court, yeah, Ms. Justice Rice in High Court.
Yeah, cool. Okay. For those people who want to look at that judgment, we'll get Meg to circulate for those people who signed on the details to that. That sounds really interesting. So for those people who are not UK based, the Court of First Instance, the High Court, it is unlikely to go beyond the High Court for that sort of judgment, and I think that will become very good case law. I've got two questions, one for Laura. And then one for Gary again, and then we'll move on to cookies, I think. So, Laura, the question I would ask is, and it's really around the EU representative. One thing that a lot of people struggle with is that the requirement for an EU representative has to be, or does it not, in the country where predominantly the processing is taking place. Is that a fair assessment? Or, for an example, Gary has an enterprise in Dublin, and say, for example, the processing is taking place in the Netherlands and France. Would that be a reasonable and proportionate response to having a EU representative in Dublin where the processing actually takes place in the Netherlands and France?
I mean, in the fictitious situation where Ireland left the EU as well, and they'd need an EU rep, then yeah, maybe. But an EU rep is the contact also for data subjects. And though there is no strict legal requirement, basically the advice or guidelines that the European Data Protection Board issued as well do indicate that if you do not have an establishment in the union, then you can get an EU representative anywhere in the union, but it should be the place where you are processing personal data of data subjects. So it wouldn't make any sense if you weren't processing the personal data of any Dutch people to get an EU representative located in the Netherlands when you're actually processing personal data of people in Belgium, Ireland, and France. But if you are processing personal data of people located in those 3 countries, you don't need to have an EU representative in all 3 countries. Then you can choose one of those 3 countries for your EU rep to be in. But you do have to make sure that the EU representative is able to communicate with the data subject. So if you have a lot of French-speaking data subjects and your EU representative cannot speak French, that would be a hindrance in actually doing their job properly.
That makes a lot of sense. And Gary, who can be the EU representative? Can someone who represents the organisation as a DPO also be the EU representative, for example?
Yeah, no, a DPO can't. But firstly, can I go back to what Laura said there?
Yeah, sure.
I offer my services in Ireland, Nigel, because I'm Irish and because of a Dublin office. I will only offer my services to Irish companies, or to people that process data in Ireland. Okay, so if for example a UK company was simply processing the data of a French individuals and they have any customers in Ireland or any reason to be in Ireland, then I wouldn't act as their EU rep. Okay, I will only act as an EU rep for customers who have clients in Ireland. It's a very grey area, but I'm erring on the side of caution. Lots of people do offer the services throughout the EU, having little post boxes, but I don't. One of my strict criteria is that they must have clients in Ireland. Okay. Secondly, yeah, who can be an EU rep? Well, it can be a natural or legal person established in the EU, established in the UK or EU, whichever rep you're going for. It can be a law firm, for example, or a consultancy such as DPAS. And they'd be mandated by way of a services agreement. It could also be an individual consultant. They would be mandated by way of a consultancy agreement. Data protection officers cannot act as EU rep, simply because it conflicts with Article 38. Okay, Article 38 requires that a DPO must be autonomous and independent. And so when you're mandated by a company to be their EU rep, you're not acting autonomously. You're acting under the instruction of that company. So there's a clear conflict there. And whenever I receive such an inquiry, I do send one of them out to if I'm a DPO for an organization, I don't act as an EU rep to the same organization. Yeah, and yeah, so that's really it, Nigel, in respect of that. But yeah, you can be one, and you need to be careful though as to who you're actually using and what sort of contracts in place. You need to be sure, for example, that as Laura said, the language issue is agreed, the translation, things like that. You also need confidentiality clauses included as well, making to make sure that the information remains confidential. Response times, who's responsible for those? Is there a contact in the supervising in the EU reps that can act quickly should there be a data breach or anything that needs acted upon? So there's lots of little things that need to be looked into, but on the whole, yeah, there's no strict criteria as to who can be a rep or not.
Cool. Okay, Gary, thank you very much. I just want to move on to cookies now, and I'm conscious that of time's ticking away. But Laura, just quickly, I understand that the Dutch Data Protection Authority has been busy again, hasn't it, around cookies? What have they been up to?
Well, yeah, in the past years, the Dutch Data Protection Authorities published their focus areas, and one of the focus areas was about online environments and the use of cookies by companies. They haven't regulated in that sense, but they have done some investigatory preliminary checks. So they actually checked a couple hundred websites from large organizations, and found that over half of them were breaking the law. So they ended up sending them all, like a reprimand and asking them to change their ways. And you did notice some of the larger Dutch online retailers, as well as a lot of media that's changing their cookie banners very shortly after this news went online. So it's very likely that they were acting on encouragement by the Dutch DPA.
We like encouragement. We like encouragement, and that's what it's all about. Paul, you have a lot more expertise in this area than I would. In terms of cookie enforcement, what's new beyond the Dutch regulator getting stuck into Dutch companies? What's the landscape looking like in the cookie land?
Expertise is probably the wrong word. I own another company called CookieScan, who offer a cookie management platform. So we've done a lot of research into this field. The French have done the exact same as the Dutch. They put out quite a stern warning to website owners in France about their cookie compliance. Ireland looked at a number of websites and again gave them a 6-month period to get their house in order. They got quite a big survey.
And Paul, what area is their house not in order?
Well, the legal requirements, if I just go on, under the e-privacy directive, which is now an agreed regulation, is you have to get true consent from website users for non-essential cookies. So non-essential cookies would be any cookie that's involved in marketing, some analytical cookies, some preference cookies. So you should see a banner where they've categorized cookies. So essential cookies would be cookies that are required to actually run the functionality of the website. So there should be a clear yes, no consent for the data user or for the website user. There should be information provided on what the cookies are, a brief description of what they do, how long they remain on your device, so what the expiry date is, and where possible, who provides the cookie. So whether it's a first-party cookie or a third-party cookie. And then people have a clear way of saying yes or no.
What happens if they say no, Paul? If I want to, we're all, every single website that we go on now, or most of them, we go on to now, we're faced with a cookie wall as such, and some of us, and I'm as guilty as some other people, of sometimes saying, oh yeah, let's just move on. I want to book my holiday or my flight or something, and I just move on quickly, and I shouldn't do, but I'm just as guilty as everyone. What if I say no? What if I say no? I'm not.
Well, the cookie functionality should not work on the website, so you shouldn't get directed advertising. The website owner should not get personal data in relation to statistical use of the website. It should turn it off. And if you've got a good cookie management system or platform, they should be blocking cookies from a domain level rather from a device level. So your consent, you have to get consent before you load a cookie on a person's device, whether that's a laptop, tablet, phone. The keyword is before. A lot of cookie management systems will allow the cookies to be loaded and then give you a fictitious banner saying yes or no, and you're not actually turning them off. All you're doing is ticking yes or no. Make sure whatever cookie platform you use, if you have a website, it's blocking from a domain level. That will then mean you're compliant.
No, Paul, you know me. I love to be devil's advocate, but so what? So what if I have a cookie stored? Well, what's the risk associated if I have a cookie stored on my computer?
Well, the risk associated with it is your privacy. I mean, GDPR is all about your privacy and having control over your data. So if I am a website, I'm a marketeer, for example, I load 400 cookies up onto somebody's device. They just click yes. Well, that gives me the ability to track that person, be able to track their shopping methods, what they like, where they like to go, where they like to eat. And then I just bombard them with a ton of directed advertising. It would also give me an opportunity to get geolocation of that person. So I know what countries they're starting to look at, where they're traveling to. So they can be quite intrusive. Now, not all cookies collect personal data, but the majority do. They collect your IP address, and GDPR is quite clear that IP is personal data. So it can be very intrusive. So saying no, going back to your previous, Google have recently, the landscape for cookies, Google announced they're going to abolish all third-party cookies from their browser as of 2020. That's been delayed now until 2023, until they come up with an appropriate system as to how to do it, because they've realized that it's a huge industry. Marketing and advertising and ad tech, they need a way to be able to deliver this. So by getting rid of third-party cookies, I mean, Safari got rid of third-party cookies back in 2017, so did Firefox, but they gave an option for people to turn that back on their device. Google will not give data subjects that option. They'll just get rid of them. But what Google are going to do is they're going to start using what they're calling a privacy sandbox. So it really makes them sound brilliant. They're really looking after our privacy. But what they're going to do is they're going to put you all in a stable. So people who like fishing, camping, adventurous holidays, buying equipment like that will go into one particular box. People who like doing something else go into another one. And then you can get advertising based on your likes. It won't be directed. So you'll no longer get bombarded with adverts when you search Google for fishing rods, but you will get bombarded with adverts for adventure holidays and camping and all this sort of stuff. So they're not really getting rid of it. They're just controlling people's use of their browser more than anything.
Paul, can I just clearly you're very passionate about that. This is great because it's your business, and it would be wrong if. But Laura and Gary, have you got a view really? And you know, most small to medium enterprises have had a difficulty with GDPR. They put GDPR in place. They put compliance regimes in place. They've had COVID. They've had to deal with, and now all of a sudden they're being chased for cookie banners, which for most businesses seem quite innocuous, but clearly Paul's articulated a very good reason why we need this regulation in place to protect privacy. What advice would you give to SMEs, particularly around complying not only with GDPR, but the privacy directive? What advice would you to be able to stay on the side of what's perceived to be two bits of different legislation?
I think it's a difficult question to answer. Obviously, for SMEs, it can be harder to meet certain requirements, even though GDPR recitals do mention proportionality when it comes to SMEs. And for example, in the Netherlands, the data protection authorities also have indicated that they want to act proportionally. You still have certain requirements that you have to meet. And what I find often happens in SMEs is that there's not an unwillingness to meet these requirements. There's just a lack of knowledge as to what these requirements are, as well as how they can find out what they are. And sometimes then a lack of budget to actually implement those requirements properly. So if I'm an SME and it comes to marketing, I mean, as with everything else, if you are unsure about what your requirements are, I would always suggest to look for outside help. And outside help doesn't necessarily mean Google. It means actually finding someone who knows what they're talking about. And I think in the Netherlands, for example, there are a lot of different ways in which you can get expertise that is matching your level of business. It's also a question of making a risk assessment. If you are an SME and you're only processing bare minimums of personal data of your clients, then you've got a different risk level than an SME which is processing medical data, for example. I recently had a encounter with a SME which provides like childcare planning and tracking systems, which could involve medical data. It's following the children's development, but it's only a 6-people company. And then you realize that their marketing manager and sales manager and account manager is also their DPO, who wrote the privacy policy in June 2021. And it's clear that they aren't aware of their requirements under GDPR. And that's a situation that you see a lot. So I think for them, it's important to get the right help and the right expertise to be aware of what their requirements are and then implement them one by one. And one of the things that they run into is that they say they want to be GDPR compliant with their cookie banner. They don't realize that that's actually based on e-privacy directive, which in the Netherlands is translated into the telecommunications law. And we see the same thing now, where there used to be in the Netherlands the right to object to telephone marketing. As of tomorrow, you'll need consent. But it's highly doubtful to me that a lot of SMEs are aware of this change and able to implement it. So.
Yeah, cool. Thank you very much. One of the things I did through my academic studies, and I always tell my students is that the reason why the UK introduced the 1984 Data Protection Act, whilst it was a recognition of the 1981 Convention from the EU Council, and the reasons predominantly were business driven. They were, one, the ability to trade with the rest of the world and be able to transfer data across it. But two, one of the main directives was to secure personal data of individuals, but more importantly, the government put more emphasis on reducing the burden on business and to do as minimal as possible. And I think that one of the challenges SMEs have, exactly the same as you said, Laura, is that everyone's doing everything. They've got the double whammy of GDPR and also COVID. They've also got new e-privacy directives and cookie control coming forward, and it's really, really a hell of a challenge. I'm just conscious of the time, and just leave Paul with the delicate subject of what his view is. And Paul, without flogging your own product, but I'm sure that professionals like you, are people able to help and assist SMEs, because it's really difficult, isn't it? If you're an SME, you're based in Jersey, you're doing business in France, you're doing business in the UK as well. It's a bit of a challenge, isn't it? These conflicting pieces of legislation that you've got to apply.
Yeah, exactly. And I mean, as Laura said, go out and get help. Do not use Mr. Google, because you won't be able to find what you're looking for if you don't know what you need in the first place. And it's quite clear. And using expertise like Gary's, Laura's, or even my business in the Channel Islands, we keep up to date with change. So where there is a change in legislation, and the great example Laura just gave was the change in the telecommunications requirement for direct marketing in the Netherlands. Mr. Blogs down in company ABC is not going to know that. And in the next time, 12 months' time, they're going to be a breach of that law, and they could start getting complaints. Cool. So having somebody on board who knows about these changes. In the arena of the cookie world, there are going to be changes. I mean, again, shop around. You will find products like ours that are little as £5 a month. You're completely compliant. And you'll find other products that are more expensive than that.
Other products are available, Paul. Yeah,
they are available. There's a lot of products out there, and there's a lot of consultancies who all do a good job.
Cool.
So shop around. That's all I'll say.
Thank you very much. Great advice, Gary. One last comment. One last comment from you.
On cookies, I think it's about awareness, Nigel. Certainly in the UK, the ICO, I think, don't seem to do an awful lot with cookies. I never see much enforcement for cookies, for example. So I think it's about raising awareness. Any of my clients who have cookie banners that are not compliant just simply weren't aware that it was a requirement, and what they needed was swiftly added to it. So in terms of cookie banners, it's awareness in the UK anyway.
Cool. Yeah. One final comment from me about cookies, and Gary raised an interesting point about compliance in the UK with the ICO, Information Commissioner's Office. And one interesting thing is that there was an admission about 12 months ago from the Information Commission Office, particularly around ad tech. That's a very complex area of regulation. And we have a client who is in the ad tech industry, and it is very complex. If you ask them to map out, you ask them the data flows and the environment that they work in, it is extremely complex. And I think that there's a recognition that for enforcement to take place, then there needs to be understanding. And certainly the Information Commissioner had a call for ad tech cookie experts to join them to aid their development of successful regulation in this area. So in defense of the Information Commissioner, I know a lot of people give them a hard time. I'm not one of them, because I'm, having worked for 2 regulators in the past, I understand the complexity and challenge they've got. But to get a successful enforcement, one has to have a basis of knowledge in the first place, and they necessarily haven't got that in place. So I think that's really important. Look, ladies and gentlemen, we always end up after 50 minutes of concluding. I just want to thank Gary, Paul, and Laura. Thank you very much for your time. I've worked with all 3 of you, and it's absolutely fantastic to see you all well and safe. We have on the call today a number of people from not only the UK, but the European Union and the Channel Islands as well. And if you need any of the services, you know, it's not a blatant flog, but there are certain people here that can help you. So don't be scared to contact them should you need their help. It is a complex area. And as Paul correctly said, you know, I wasn't aware, for example, and I'm the biggest law geek, the biggest court case geek out, and I wasn't aware of Ronus versus Lexis. So I am going to look that up, because I'm that sort of guy. Be safe, everyone, and I hope you try and have a safe summer as well. And we'll see you soon. And thank you for joining Privacy Post. Thank you very much.
Thank you.
Thanks,
Bye.
everyone.
Thank you.